Yep.
Good evening and welcome to the July 15th Kent County Board of Adjustment meeting. I'm calling this public hearing to order. Will you, when you're ready, call the roll?
Ms. Hudson,
Here.
Mr. Saunders,
Here.
Mr. Jenkins, Mr. Kusick, Mr. Crossan,
Here.
Mr. Carter,
Here.
and Mrs. Denny.
Here.
Vote shows 5 present, 2 absent.
Thank you. Will you introduce the staff?
Good evening, everyone. My name is Scott Blair. I'm one of the planners here with Kent County Planning Services. Also to the left of me is fellow planner Jamie Fensky, and across the room, sitting at that table, is Mr. Fred Townsend, who will be the board's legal counsel for this evening.
This time I'm going to ask everyone present to rise and pledge allegiance to our flag. And here comes Mr. Cusick. So as he is walking in, I will, this is another member of our, of the Board of Adjustment, Mr. Cusick. So we have even a bigger quorum now. Any additions or alterations to the agenda? Okay, so will you introduce the public hearing?
Yes, thank you, Ms. Denny. Good evening, ladies and gentlemen. My name is Scott Blair, and I'll preside as the hearing officer for tonight's public hearing. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on these applications before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there shall be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. The chairperson of the board has the discretion to allow additional time if deemed necessary. To make a statement when your application is called, please use the podium at the front of the room. If you are participating online and wish to give testimony, please push *3, which will raise your virtual hand, and we will unmute your line so you can speak. For the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each variance application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by staff. The board will then receive testimony for all those in favor of the application, followed by testimony of those who may be opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call Kent County Planning Services tomorrow between 8 a.m. and 5 p.m. at 744-2471 or check the Kent County Planning Department website to learn of the board's ruling. All applicants will receive written notification of the board's decision. However, this notice may not be mailed until after the next scheduled meeting. But if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearing was published on June 28th in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications. Thank you.
Thank you. I can see that several of you came together and you're separated by the seat dividers. And if you need to be able to speak with each other, feel free to just remove the cellophane and put your, so that you can be together. I could see you all come in and so please feel free. At this time, we're going to have a statement by counsel, the purpose of which is to help those who are going to give testimony this evening a better understanding of what is acceptable as testimony before this particular body. Mr. Townsend.
Thank you, Ms. Denny. The test for the granting of area variances is set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty. The test is whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. And to determine whether the exceptional practical difficulty test is met, this board must consider the following 4 factors: the nature of the zone where the property lies, the character and uses of the immediate vicinity, whether removal of the restriction on the applicant's property would seriously affect neighboring properties, and 4th, whether failure to remove the restriction would create an exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is met only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. The inability to improve one's business may qualify as an exceptional practical difficulty or may justify one. And this consideration is where the board asks whether the applicant is seeking more relief than is minimally necessary to relieve the asserted difficulty. In general, the board is not to consider factors other than the ones I've listed. Therefore, those speaking both in support of and in opposition to applications are urged to present only information bearing directly on the nature of the zoning district, the characteristics of the area, whether the requested variances would seriously affect neighboring properties, and lastly, whether the applicant is confronted with challenges rising to the level of exceptional practical difficulties. In particular, presenters are instructed to exclude from their presentations any discussion of personal disputes or acrimony between the applicant and neighboring property owners, as the board is not authorized to resolve those disputes. Those are my comments, Ms. Denny. Thank you.
Thank you so much. At this point, when you're ready, we'll begin.
Okay, thank you, Ms. Denny. The first application for the evening is A21-22. Is there someone here to represent this application tonight? Just please raise your hand at this point and we'll call you up later for testimony. Anyone? Yes, great. Thank you, Mr. Johnson. Okay, so again, this is A21-22. Jackie M. Johnson Jr. seeks a variance from the 30% maximum impervious coverage to place a lean-to off an existing garage. And the property is located on the northwest corner of the intersection of Division Street and McKee Road, 446 feet south of School Lane, west of Cheswold, Levy Court District III, and it is zoned RMH. So this is a plan of the actual the property in question, and you can see there is a garage there, and the applicant has proposed adding on a 24 by 12 lean-to onto that garage. You can see the existing impervious surface is 44.2%, which is above the 30%, and he is proposing an additional 2.4% for a grand total of 46.6% impervious surface on the site. This is a photograph of the applicant's house with of course, the sign posted out front. This is another shot down Division Street. This is, you can see in the background, the garage in question with the door there. That's where the lean-to would come off of. And I would also note there's also a sidewalk there, kind of where it will be going. This is another photograph of the garage and the paved driveway, both concrete and asphalt. Another view again of the garage. Again, the lean-to would come off where that black door is on the side of the garage. Just another photograph of the area. This is an aerial photograph to give you some idea of how much impervious exists there now with the different structures in the driveway. And this is a farther up shot. It kind of gives you some flavor of the character of the area and what other structures and things are on people's property. Okay, if Mr. Johnson, could you come up, please, and have our attorney just give your name and address and allow him to swear you in, please?
My name is Jack Johnson, 3891 McKee Road, Dover, Delaware, 19904.
Mr. Johnson, if you can pull that microphone towards you somewhat, thank you. Do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Please proceed.
I guess evidently, whoops,
No, that's good.
you have agreed, to put the lean-to up, providing, you made arrangements, and stuff, on it, really. But I guess what I'm going for right now, and of course you approved that and everything, but I guess is what they call the hard surface, where
That's correct, an impervious surface.
Impervious, yes. And anyway, I just feel that we don't have a problem, really with runoff and water and stuff and everything, because it's rained there quite a bit, really, and anyway, there's no puddles and everything. I'm not, backing up in people's yards or anything like that, really.
Okay, well, let me, first of all, kind of try to explain a little bit to you. The reason that the code provides for impervious soil regulations is because, as you might guess, if everybody were to pave or, put, buildings up and pave, more than half of their property or half of their property, eventually everybody in the county would have some type of a water issue because rainwater has to have a place to go. And yet we still have to have streets. You still have to build homes. Homes often require driveways or a garage. And so the code make provisions in the code to protect us from everybody paving too much of their property and then causing subsequent water issues. So I just want to say that. So at this point, maybe you could help us by telling us why you've paved so much and why it's necessary for you to have the lean-to. That would be helpful to the board.
Well, as far as the lean-to and everything, me and my wife have been talking about it for the last couple of years. And anyway, we could have retired last year, but we elected, I talked to her and gone to maybe another one more year or two, but hope she didn't hear that. But but she's I've been with paving company George Lynch for 45 years, and I'm still paving, and water does go through blacktop. And she's been on the job too, for 45 years. And we just figured, well, it's just something where her and I, we could just set out when we retire, and just sit back and. Lord knows, what happens to us after that when we retire, really. But from other than that, that's the honest reason why. Because, let's face it, Delaware, if we do get any kind of rain, we're below sea level anyhow.
Well, every once in a while, we get one of those 100-year flood events, and they're not necessarily 100 years apart.
Right,
So anyway,
yes.
but at this moment, I'm going to see if any of the other members have questions for you.
Sure. Mr. Johnson, I'd like to ask you a question.
Oh, okay.
It's been brought to our attention that the property is already over
Yes.
the required, which you know.
Right.
And now you're wanting to add some more. I noticed that on one of the photographs, it looked like you had a really nice deck off the back of your house.
Yes.
And you also stated that you basically, it's not medical or anything else, it's just the fact that you want to have a place to sit with some shade and out of the weather. Well, a retractable awning, that's what we did at our house, right off the deck, looks just like yours. It works perfect. I mean, that would give you all the shade you need.
Right.
And you might not sit out there when it's raining, but that's up to you. So there are some other options. You could also put a little temporary seasonal structure out there for shade that they make. So that you do have some other options other than this lean-to that will give you shade.
Right, yes.
Thank you.
Anybody else? Okay, so back to me. So tell me how this happened. First, you had your home, and then you built the deck.
Yes. Uh-huh.
And then after that, you added the garage
Yes.
and the shed.
Shed,
kind
yes.
of like in that order. And so, because obviously, as it exists, you're over. And my guess is probably the driveway may
Correct.
have been what tipped the scale. And it's a huge driveway as well compared to it's bigger than your home.
Right. Mhm.
And of course, you don't have to have a permit for the driveway, and so I'm sure that that wasn't on your mind when you put the driveway in, like about impervious soil.
Yes.
So we're already over. And when I see some of this, I try to figure out how did we get to over without permits. But if the driveway came last, then I understand. But so the lean-to is just so that you can sit outside. I mean, what's it?
Well, we just sit outside and put stuff, under it, really, like our barbecue grill and stuff like that, really, and some chairs. Although we do have the deck up, the deck too also.
Okay, well, that's, I guess, all the questions I have. Anybody else?
I have one question. So you already went through the permit process
Yes.
for the lean-to.
Yeah, and I think they approved it because it was supposed to be like 24 by 14, and then after that, they had it down to like 24 by 12, yes.
Correct.
And they said if I do it that way, then after that, they would approved it, really.
So how far along are you with the contractor? Do you have a down payment down? Is any money, any hardship loss for you?
No, he's family. He's an Amish guy, but he's married in my family, But it all depends on the night, really. He was supposed to be here tonight, but he couldn't make it.
Just for clarification, yes, a permit was applied for, but it was not approved. It was flagged for impervious, which we're here tonight to thank you, just for the record.
Okay.
Okay, anybody else? Thank you.
Thank you, Mr. Johnson.
All
Is
right,
there-
thanks. I didn't realize that was you, Scott, over there. All right, thanks.
Is there anyone else who would like to give testimony in favor of the application? Anyone? Anyone online, Mark? Push *3 to kind of raise your virtual hand.
There's no one online at this time.
Great, thank you. So is there anyone now in opposition to this application? Opposition in the room? Or anyone online? *3 to raise your hand if you're in opposition to this application.
No one in opposition online at this time.
Great, thank you. Okay, well, since there's no one else both in favor or in opposition, A21-22, the public hearing is now closed.
Next, we have application A-21-23. Is there someone present for this application? Thank you. All right, so we have Miss Lisa Skew-Soloway. She's zoned to AC. She is proposing a variance from the required 75-foot front yard setback to construct a porch. Present use is residential. Proposed is same with a porch. She's in Miss Joanne Maston's first levy court district, located on the southwest corner of the intersection of Smyrna-Lipsick Road and Big Oak Road, east of Smyrna. Miss Holloway did come forward last year for a variance. She was granted her variance for the same request. Her variance did expire after 1 year, so she's coming forward to ask for the same variance again. She's asking for approximately 64.9 feet from the front setback. The required setback is 75 feet. You'll see here the front of the home, where the front porch is going. Looking down the road, at the intersection of Big Oak and Smyrna-Lipsick, down Big Oak and at the front of the home, the other side, front, the area, the further above. Ma'am, if you would like to come forward and state your name and address and allow our attorney to swear you in, please.
Lisa Skuse Soloway, address is 2752 Big Oak Road, Smyrna, Delaware, 19977.
Ms. Soloway, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do. So I'm here again. I was actually one of the first ones when the board did the Zoom Board of Adjustment hearings. And unfortunately, with COVID, construction, and the lack of lumber, I was not able to do the renovations to the house that had been planned. And in that process, I also didn't realize that the variance expired in a year. I remembered, or I saw it 3 days after the fact. And then I spoke to Scott, and Scott said you have to reapply. So that's why I'm here again. Nothing has changed. The house was built in 1958 is the last testimony that I gave last year in May. It's 3-bedroom, 1 bath. Doesn't work for a family of 4, especially teenage kids with 1 bath. So we're looking to expand. And the reason we're going up is the porch will, add aesthetically, but then that's where we're putting the other 2 bedrooms, and the other bath is up rather than going out.
Anybody with any questions? Mr. Townsend?
Ms. Soloway, I think you should assume that this board does not recall that event.
I don't recall that event. It was by Zoom.
Right. So this is your opportunity to tell the board why you should be granted the variance and why it's not harmful to your neighbors, and why you're faced with an exceptional practical difficulty in the absence of.
Absolutely. I inherited this house. My intention is to move there. I own all the property around it. It's a total of almost 6 acres. So all the property surrounding it belongs to me as well. And the porch on the front is just 8 feet. And like I said, it's mainly so that we can go up with the house and then eventually live there. We could 3-bedroom, 1 bath, but it's more of the transition of keeping the house in the family and being able to go back there with the family that I have now. And the neighbors, it's my family. My brother owns the property across the street. The lot that is actually adjacent and has the horse barn that also belongs to the house and the property that I have is my other brother. So there's really no hardship to anyone that the 8-foot front porch is going to cause.
So I do have a question.
Sure.
Which is, and you probably answered it before, I probably asked it before, but I don't recall. So essentially, you're building a porch.
Yes.
But the porch is the base for an upward addition to the house.
Exactly.
All of which meets the code.
Yes.
It's just, other than the setback.
Just that 8-foot out front for the porch. And the only portion, if you were to look at the house front on, it actually has my parents, the original part of the house was on the far left if you're looking at the screen. That was the original part. Then my dad added the second portion in the middle, and then the garage. So when you look at the house, of course, the green tree is blocking it, but it's actually 3 separate roof lines. So our intention is to just take that center portion and go up. And we're going to do that by just putting an 8-foot porch out on the front. Again, because we're going up just that center portion. So it's not the whole span of the house.
Okay. Anybody else? I think we're good.
And I do now know that they expire in a year, so. Thank you.
You're welcome.
Is there anyone else that would like to speak in favor of this application? If you are on the phone, please press star 3. Is there, oh,
There's no one online at this time.
thank you. Is there anyone that would like to speak in opposition of this application?
No one in opposition online at this time.
Thank you. At this time, we will close the public hearing for application A-21-23.
Okay, the next application up is A21-24, John Cox. The owners are Abel Rivas Ortiz and Joseph B. Mendez Lopez. Is someone here tonight to represent this application? Thank you. We'll call you up after we're done the kind of the overview. So again, this is A21-24. They're seeking a variance from the required 75-foot front yard setback to construct a single-family dwelling. The property is located on the north side of South Little Creek Road, approximately 216 feet east of Signal Road, south of Dover, and it's in Levy Court, District 3. So this gives you some idea of the plot plan. So you can kind of see in the background there is an existing single wide there that is currently about 60.4 feet to the front property line. The proposed dwelling is the one story you see there, and that will be 64 feet back from the front property line. Again, the requirements on a major road is 75 feet, and they want to be 64 feet, hence the need for a variance. This is a front photograph of the sign posted in the yard, and you can see the existing single wide with porch there. This is another view of that same dwelling. This is taking a look down Little Creek down to the east towards the bay, and this is towards the west towards Dover. You can see the sign there. Dover's incorporated area is all around in this particular property. They're kind of an enclave in Kent County still. This is an aerial photograph to give you some idea of the character in the surrounding area. You can see it's a very large lot, actually, and the need for the variance, you can see there's not a lot of room in the back either. And this is just a higher up aerial to give you the character and kind of the surrounding area. Okay, if we could have the applicant come up or someone representing and have our attorney swear you in, please, and give testimony.
Hello. John Cox. My address is 21 Decker Drive, Newark.
Mr. Cox, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, so now you tell us what you're trying to do.
Okay. I think that one right there is the best one to look at. Abel came to me and said, what can I do with this lot? He has a single wide. As you can see, the dashed line, it's ghosted in with the front porch there. He's been living there for quite a while. His family has grown. He has he's on kid number 3, and he's going to have kid number 4 soon. So he came to me and said, I need to build a house. And looking at the lot, as you could see, there's it's a long and thin lot. And with the 75-foot setback, basically what you have, the summary of the hardship here is that we have a very small, or shallow, I should say, shallow and long buildable area. And if you can imagine building a single-family house, in a long, thin area, it becomes difficult. So, I told Abel, I said, why don't we try to, go for a variance here? So I did some sketches and came up with a floor plan that I think works. It's not fully flushed out here, but what we're asking is to come into the front yard 11 feet from the 75-foot setback. And the remaining setback is 64 feet, as you can see. There's really no other variances. The pervious area is, we're within that. The use is single family, and we're only proposing a single family house. So, really, I think that's it. There's also other elements in this plan. It's not fully developed yet. A new shed in the back, and replacing a tree and adding some other pervious and impervious areas. But mainly it's the setback for the single-family house that we're here talking about today. There will be a one-story addition onto the right, as you can, where it says one story, that'll be a garage. And it's not called out here, but the entrance portico to the house, where the front door will be, you can see there's another rectangle there between the two, one story and two story. You can see the right, yep, exactly. Thank you, whoever's doing that. So, in my opinion, I think the setback doesn't really affect neighboring properties. It will be less than the existing construction, which is grandfathered in. I think it'll be an improvement. I think it'll aesthetically be an improvement to the neighborhood. I think, and as far as being a hardship, I think if we're not granted the variance, I think it will make the design of the house an interesting challenge for me as the architect. But I think realistically, to build a new house in that footprint would create a challenge and a hardship for my client. So for that, I request a variance for the front setback of 75 feet. Pardon me, I'm a little nervous up here.
Well, that's okay. We don't bark or bite.
Yeah, you seem nice enough people. Yeah, the other thing here, it's an agricultural zone, which I imagine most agricultural zones are probably much more than 1 acre. This is about 1 acre, I believe. So if you imagine if this were a 6 acre lot, it would be much easier to place a single family house on it. But being that it's so small, it's really constrained. It's very long and very thin lot, so it makes it difficult to really place, a simple house on that lot. So I think I've gone on enough about that. So I think that's the nature of what I'm proposing here tonight. So thank you very much.
Okay, so does anybody have any questions? All righty,
May I ask a question of staff?
go ahead.
Thank you. So if the application is approved, is the footprint of the proposal what the applicant is limited to, or is there a suggestion by the application that we're going to reduce the setback to 64 feet all the way across the front?
I guess staff's understanding, Mr. Townsend, is the 64 feet would enable the placement of the home. It's not necessarily a blanket setback, a new setback at 64 feet for any new accessory structures or anything like that. Those would require a separate variance.
So the reason I'm asking is there were a couple of references during the presentation that the plan may not be fully fleshed out, and I want to make sure that we don't approve something, if the board were to approve it, that the applicant later would determine he or they could not work with. So,
May I speak to that?
Of course.
Yeah, I apologize for the putting that out there in that way. The intention here is, yes, to the footprint that we've outlined in this plan is one that we plan to work within those constraints. So, 32 feet is the depth of the main house, the two-story, and as you can see, it's identified as 40 feet wide. So we would work within those boundaries. As I did mention, there is a small portico to an entrance. It is it is described in on the application verbally, but it just didn't, on this particular plan, it wasn't identified, but it is a 6 foot by 8 foot entrance portico. It does appear on the plan, it's just not immediately identified on that plan that we're looking at right now. But yes, so in summary, yes, what's shown on this plan, we will work within those constraints.
Okay, so your testimony is that including the portico, you need 64 feet. You need a setback of 64 feet, which includes the portico, because porticos are more often than not attached to the house, which means the setback is the setback is the setback. So that's a yes? We're good?
Yes. The 64 feet that we're proposing is the maximum encroachment, or rather the minimum setback, I should say. As it's shown on the plan, the 40 feet plus the 8 foot wide portico that's also shown.
Yeah, that portico is tucked back in, it's between the 2-story and the 1-story, that little box.
Oh, I
Yeah, there
see,
you go.
yeah. I missed that, okay, all right.
But it's still
Sometimes
in
you might
it's
see
still
a
in the area
portico
where-
sticking off the front of a building, but that's not what we're saying here. It's behind the 64 foot setback.
So really, the design doesn't mean anything. So we're approving that 64-foot setback, so that 75-foot setback is now 64, and he could put his house anywhere within that.
Within that, yeah.
That's correct. And I misunderstood, Mr. Townsend and Jamie, correct. Yeah, there are side setbacks, as you can see, so he can move laterally side to side. He just can't go forward to the 64 feet. I misunderstood you, Mr. Townsend, sorry. So I didn't mean it had to be at that exact spot. It just has to be set back 64 feet from the front property line and meet of course, the side setbacks if you decided to slide it one way or the other.
Okay, so now I feel like I have a more clear picture, so. Anybody else? Thank you.
Okay, thank you very much.
Okay, would anyone else like to give testimony in favor of this application? Anyone in the room? In favor? No? Anyone online? *3 to raise your hand to speak in favor of this application.
There appears to be no one online at this time.
Great, thanks, Mark. Is anyone in opposition of this application? Does anyone want to give testimony in opposition to this application? Anyone online?
No one in opposition online at this time.
Thank you. There being no further testimony for this application, I declare 821-24 public hearing to be closed. Thank you. Okay, the next application is A21-25. Sean Bowman, is anyone here tonight to represent this application? Great, thanks, Mr. Bowman. We'll call you up after the presentation. Okay, A21-25 is Sean Bowman, executor. The owner is Janice S. Bowman Estate, seeking a variance from the required 200 feet of road frontage to enable a minor subdivision. The property is located on the northwest side of the intersection of South Dubon Highway and 9-Foot Road, approximately 0.71 miles south of School Street. South of Farmington, Levy Court District 6, and it is zoned AR. You can see from this plot plan there, what they're trying to do is a subdivision, and because there's a lot next to it, they can't get the full 200 feet of road frontage for that lot, short of wrapping around a piece of land that's, 2.99 feet onto the other side. They're requesting a variance for 197.01 feet instead of the required 200. This is a sign posted on the property and a picture of the house. Another picture of the house on the lot to be subdivided off from the other part of the parcel. Just another shot. This is looking west down the road, and this is east back towards DuPont Highway. This is just another picture, more or less, of the property line between this and the adjacent property to the west. And this is an aerial photograph. You can see the house and the buildings that are going to be subdivided off from the larger parcel. And this is just another area, a higher up aerial. You can see the character of the area, the transfer station behind it, mostly agricultural in the area. Okay, Mr. Bowman, if you could come up and give testimony, please. State your name and address and allow our attorney to swear you in.
Sean Bowman, 3909 9-Foot Road, Greenwood.
Mr. Bowman, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do. Good evening, everyone. I didn't see, and I don't know if I have a good drawing, but there are some original lot lines that I can't really see on there. But anyway, we're trying to follow, yeah, that's a good photo. We're trying to follow some of the original lot lines and not have to do a lot line adjustment. The issue, even if I came 3 foot towards my house, which I'm the small block there, if I came 3 foot towards my house, then I have an outbuilding that would then be out of compliance. It'd be too close. So I'm kind of between a rock and a hard place here. Just a little background, that all that property has been in my family for over 80 years, I think. And so the house that I would like to sell to another family member was my mother and father's house. And so me and my siblings have inherited this property. And my intention is to buy and add to my lot all the wraparound property, with excluding the 1.4 acres that the house in question sits on. Any questions?
Gentlemen, any questions? Nope, I think you're off the hook.
Okay. All right, that was painless. Thank you.
Thank you, Mr. Bowman. Is there anyone else here who would like to speak in favor of this application? In favor? Anyone online would like to speak in favor of this application?
There's no one in favor online at this time.
Thanks, Mark. Okay, anyone in the room that would like to speak in opposition to this application? Opposition? No? Anyone online who would like to give testimony in opposition?
No one in opposition online at this time.
Okay, thank you, Mark. Okay, since there's no further testimony, A21-25, Sean Bowman, the hearing is now closed.
Next, we have application A-21-26 for Hardesty. Is there someone present that can speak on behalf of this application? Thank you. So we have Mr. Hardesty. He is zoned AR, which is agricultural residential. He's proposing a variance from the requirement that an accessory structure may not dominate an area, the principal use or structure, in order to build a pole building. The present use is residential. Proposed is same with accessory structure. It's in Levy Court District 2 for Mr. Hall, located on the east side of the intersection of Blue Heron Road, approximately 469 feet northwest of West Denny's Road, west of Dover. As you'll see here, the home is 2,635 square feet. They did enclose the attached garage. The proposed building is 3,000 square feet. The proposed building is 50 by 60. You'll see here the front of the property, down the road, in the other direction, looking at the front of the home, down the driveway in the area of where the pole building is proposed to go, the property, aerial, and the farther above. Mr. Hardesty, if you would like to come forward and state your name and address and allow our attorney to swear you in.
Scott Hardesty, 192 Blue Heron Road, Dover, Delaware.
Mr. Hardesty, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. Good evening, everybody. It's nice to be maskless for once. And yes, getting back to normal a little bit. Bear with me, I have a little bit to read off here, and I'll take your questions after. The property at 192 Blue Heron is a wooded lot as a whole. The only cleared land is the home and the outbuildings, which it sits. Of course, you know that the property is owned AR. And the building I'm under contract with my contractor is a 50 by 63 pole car garage with an unfinished storage space upstairs. It's been expertly configured and inconsistent with all the other homes in the neighborhood with large pole buildings. This pole garage is a fancy custom two-tone building that will match the home with large dormers accented with a cupola and eyebrows. As you can see on Exhibit 2, do you have that?
Yeah, we have it in our package.
Okay. This building will only enhance the property value for years to come, and it will not look out of place with the surrounding dwellings. It will serve only to enhance the value of the other surrounding properties in the neighborhood. None of my neighbors have an objection to it, both sides, and have wrote letters. Both of my parents passed away last August in 2020, and I am the only son and executor and heir of the Blue Heron property. At the beginning of this building project, around the middle of January of 2021, I found my father's original approved blueprint of the home, which stated that the home was 3,400 square feet. The pole building was 3,000 square feet. No problem, I thought. So I signed the contract to order the trusses and the pole beams before the lumber was about to spike around that time. And my contractor put it in, and it didn't take long to deliver, and it was very ahead of schedule. They dropped the trusses and beams off on the lot at Blue Heron in March of 2021. My contractor put in for the permit to build the home and brought the blueprints to show the square footage of the home, but the county looked the home up on the computer and showed a discrepancy in the footage, as it was only showing 1,800 square feet, and stated that they would need to come out and do an assessment, which they did. And I received a phone call later that afternoon saying that the property was only 2,135 square feet, that I would need a variance. So to help remedy the situation, my wife and I decided to enclose the two-car attached garage to the Blue Heron home, which is nearly complete now. With this, it gave us an additional 500 square feet added to the home, bringing the total up to 2,635 square feet. We plan on making this our forever home. It's where I grew up, and we're doing a complete model of this home. We've already replaced the septic system, the heating and air ventilation system, replaced the sidewalks and landscaping, as well as plans to update the kitchens and the bathrooms. And the most important piece of this project is adding an ensuite that would give us another 700 square feet added to the home, bringing it up to around 3,400 square feet by spring or early summer of '22. That would be on Exhibit 3. You can see that on the end of the home. I grew up at this home. It's 50 years old, and it needs some renovations. My parents, over that 50 years, had acquired a lot of assets in that time. My wife and I, we still have a home in the Hartley area. And we have 30 plus years at this home, raising our families, and we have many assets of our own. I have a large 3-car garage and a workshop and storage upstairs with many assets stored as well. And it would be a probable loss if I just brought it over and left it outside. It more than likely would probably be stolen, or it would deteriorate in no time. The pole building would provide us the storage we need now and for our children when we pass the property down to them in the future. But until this happens, we're unable to sell our Hartley home. It would be very costly for us to rent a large storage space or rent 3 to 5 or more pods to put the things in. Plus, having to move our assets twice is not only a physical burden on the two of us, but runs the risk of damaging our assets as well. We have had an estate sale, we've had yard sales, we've sold things on the internet, plus we've given things away and gotten rid of a lot of items. But still, there is little to no room at the Blue Heron home with my parents' assets to make the move. So right now, we're constantly running every day back and forth to the 2 different properties to check on them and check on the other house and mowing the grass and paying the bill over there and updating and paying the utilities and insurance and taxes on this other home. And it's putting a substantial monetary hardship on us as well as a physical burden, since it's just my wife and I. We had planned on selling the Hartley house early this spring and used the money to pay for most of the renovations, but this has been put on hold because of the discrepancy. The hardship is the practical difficulty of a contracted building not being built with the materials on the ground and danger of total loss, of which I've already spent $20,000 in the materials, on the honest mistake I made, not knowing that the home was under the square footage needed. So I ask council to please consider the approval of the variance, that we are doing everything possible to stay within the guidelines and rules.
Anybody have any questions?
Yes, I have a couple of questions. It looks like, according to the plan of the structure, that you have a reputable builder lined up. I'm just curious as to why a reputable builder is going to build a 50 by 60 foot building would even allow you to put down $20,000 for materials without knowing that there's a permit in place, or without having applied for a permit.
Yeah, that caught us by total surprise.
Caught us, or caught the builder?
Yeah, caught the builder by surprise because according to the blueprint, we did have the square footage, the original blueprint we had of the home.
Yeah, I understand that, but the blueprint's one thing, the permit's another. He can't build the building unless you have a permit, and he probably should not have accepted the money, not knowing that you did not have a permit at the time.
Correct. When I ordered the trusses and the poles for the building, he asked that I pay for those, and when they came in, and it was at that same time, within a few days, that he went down and tried to get the permit and then that's when everything kind of went south.
You know, it's done backwards. You're supposed to get the permit first and then order the building. You would have known that you couldn't have had that big a building. You could have just scaled it back a X number of square feet and you would have been good to go.
Right, and yeah, it you know, caught us by surprise, and
You also mentioned that, that the upstairs, which is huge, I think it's almost 3,000 square feet, 50 by 60 building, is to be used for storage. So you don't have any plans to do anything else, finish off the upstairs?
no, it would be too costly to, you know, do anything else with it. It's just going to be a plain floor up there to store stuff, because we desperately need the space.
Thank you.
Is there a reason why you couldn't do like a 50 by 50
Well,
and meet the requirements?
you know, it could be a 50 by 50, but like I said, the material is, the trusses and everything were custom made, and they're already there, and it's, you know, deteriorating, you know, on the ground. My wife and I have tried to do, you know, we've tried to cover it and take care of it as best as we can, but it would be probably at a substantial loss if I were trying to sell this lumber. I mean, and trying to sell it would be another issue of somebody buying this particular size and everything, and then having to rebuy the wood.
If you were to just cut off 10 feet, you would meet it.
Right. But like I said, that would throw the whole structure off, because the trusses are already
Thank you.
pre-made.
So once the addition's built on the house, you really don't need the variance.
Yes, and that's why I say we're trying to be in compliance, and that is a project for next year. Hopefully we can get our home sold in Hartley, but we need the space to store the stuff, and the material is there, and yes, so we're kind of stuck.
Okay, so in the event that the members of the board decided to vote to allow this variance, and they tied in the fact that you must, within a 2-year period of time or something, I mean, and I haven't even, obviously, we can't discuss these things.
Right.
So I'm just kind of proposing, if something like that were to happen, would you be able to work with that somewhat?
Sure.
You know, just
because,
something
like I
that would
said,
demonstrate commitment that this is a temporary situation.
yes.
Okay. Anybody else? Okay, thank you.
Thank you.
Is there anyone else that would like to speak in favor of this application? Please come forward and state your name and address and allow our attorney to swear you in.
John Voshell, 68 Blue Heron Road.
Mr. Voshell, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do. I'm probably one of his closest neighbors. I watched Scott grow up as a kid, and my property adjoins where he wants to put the building up. And to me, I see where there's no problem, because I know they are going to add on to the house, because the house, the way it's laid out, because of when it was built, is not very practical. So I'm sure they're going to do that. And to me, I mean, the building, I know they need the storage, because they have a lot of stuff that they have gotten rid of, a lot of it, but they've still got a lot of it. And I understand a lot of it is his mother's and father's that he does not want to get rid of. And that's sentimental value that is worth a lot. So I think it should be approved Appreciate your time. Thank you.
Thank
Anybody-
you.
Anybody questions?
I think we're good, thank you.
Is there anyone else that would like to speak in favor of this application? If you are on the phone, please press star 3.
No one in favor online at this time.
Thank you. Is there anyone in opposition that would like to speak on this application?
No one online in opposition at this time.
Thank you. Seeing no one that would like to speak in favor or in opposition of this application, we are going to close the public hearing for A-21-26. Next, we have application A-21-27, FAV Properties LLC. Is there someone here that would like to speak in favor? Thank you. So we have FAV Properties LLC. They are zoned BG, general business. The variance is from the required 25-foot front parking setback, 15-foot parking side setback from adjacent non-residential properties, 10-foot planted area for off-street parking that abuts a road right-of-way, and the interior planting area requirements for single-row parking with 10 or more spaces to submit a site plan. The present use is commercial. The proposed is the same. It's in the Levy Court District 3 for Mr. Angel, located between North DuPont Highway and Hatchery Road, south of Dyke Branch Road, north of Dover. Here you will see the site plan that is being submitted. They are asking for the variance from the required 25-foot front parking and the 15-foot side parking setback from an adjacent non-residential properties. They are also asking for a variance from the 10-foot planted area for off-street parking that abuts a road right-of-way and the interior planting area requirements for single-row parking with 10 or more spaces. Here's the front of the building from DuPont Highway, looking north down DuPont Highway and south, right on at the property. This is towards Hatchery. This is from Hatchery, down Hatchery to the north and to the south, the aerial above, the farther out. Sir, if you would like to come forward and state your name and address for the record and allow our attorney to swear you in.
Wilcar Ochoa, 3950 North DuPont Highway, Dover, Delaware.
Mr. Ochoa, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do. Good evening, everybody. So I'm one of the owner of this property, and what we're looking to do is we want to do in the front of the building, we want to do a pizza place. It's basically in and out, no seating. And in the back of the building, we want to do a grocery store. In the second floor of this building, we're planning on doing office for the owners where we can do paperwork. So I'm here with Scott from Scott Engineering, and he's going to explain more about this. Thank you. Any questions?
Yeah, did anybody have any questions of the owner? I have a question. So our planners have suggested a modified approval for your application. Have you seen that? Do you know what they're asking us to approve? Have you seen that?
I would say Mr. Scott here has that answer for you.
Okay. I just want to be sure that you're aware of it and you understand.
I'm aware of that.
Okay, good enough. Thank you.
Thank you.
Good evening. Greg Scott with Scott Engineering, 22 Old Rudnick Lane, Dover, Delaware, and we're here to represent the applicant.
Sir, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. As Mr. Ochoa explained to you what they were trying to do with the building, they're repurposing it. It used to be a pet store that was there, And they've got a couple different uses that will be in the building along with an office. And when we looked at the parking requirements for it, what was going to be proposed to put there was pretty abundant number that was required. And as you can see, the property's a very unique shaped property, quite narrow. And when we try to get all the parking that's required on there, we can't meet all the setback requirements from the front or the rear. It's got two entrances on it, one off Hatchery Lane, one off North DuPont Highway. To further complicate that, we had the landscape requirements that needed to be in place to buffer it from the adjoining properties, as well as the landscape islands that are required. Putting all those requirements together virtually eliminated any parking that we could put on the rear of the property, and it would only leave about 2 or 3 parking spaces at the front that we could get on the property, which would pretty much preclude having any kind of business on there that would require a moderate amount of parking on there. So it doesn't allow them to make any improvements to this business. It would basically financially put them out of business. They would not be able to locate there without the required amount of parking. As I said, it is a current commercial property. It was commercial before that. I don't see where it would have a significant impact on the neighboring commercial properties. And with regard to your question, Ms. Denny, is that we did see their recommendation on moving the parking off from Hatchery Lane to 5 feet to the west, and we have no problem doing that. We can accommodate that and still get the number of spaces that we need. So yes, we're asking for these variances in order to be able to keep them in business and not put a financial hardship on them. Happy to answer any questions you might have.
You go first.
Okay. Sure. I was just wondering if you or the staff could show us on that plan. I believe they also asked for a 5-foot planted area. Is that right? Still?
Yes, so we're asking them to shift all of the parking this way towards DuPont Highway 5 feet. So then instead of the parking going right to the front property line here on Hatchery, they will have 5 feet. So that would be a 5 feet front setback, and then they will be able to plant that 5 feet as well.
Okay, because I think there are some residential houses on that Hatchery Road, correct? I mean,
yes.
across.
Yes.
So the plantings would be both sides of the drive.
Correct.
Thank you.
Okay, so can you go back to the photograph of the, not that one, that, like the behind it? Okay, so when I'm looking at this, there's a boat and a tractor trailer there. Is that part of the property, and are they going to remain there? Because to me, they're parked there.
I believe that the boat tractor trailer is on the other.
On the other person's property, okay. All right, okay. That answers my question.
Yeah, you can basically see the tractor trailer that's there now. Yes, it's on the neighboring property to the.
Okay. It's, when you drive by to see it, the configuration, I just couldn't quite, and I thought, well, that's parked. Okay. Anybody else? I think that's all. Thank you.
Yeah, I have one.
Go ahead, I'm sorry.
So we did get an opposition letter, I think from the property, so was that? Just want you to speak to us about that. 3966, do you know which one that one is? So they had 2 comments. One was, if there's any parking in front of the subject property, it will block the view of the My Business entrance, which I don't think we're doing that, correct?
There will be no parking.
All the
that'll be
parking's in
front
the
of the
rear.
building. No.
And then the other comment was, if there is parking allowed inside of the 15-foot setback, it will devalue my property. Yeah, all right. Yeah,
Yeah, we're set back far enough that they won't even see the parking. in front of
Yeah,
his building.
I think he was more concerned on the Route 13 side, but all of our stuff is on Hatchery Road.
Anybody else? Okay, thank you.
Thank you.
Is there anyone else that would like to speak in favor of this application? If you are on the phone line, please press star 3 to raise your hand.
No one online at this time.
Thank you. Is there anyone that would like to speak in opposition of this application? If you are on the phone line, please press star 3.
No one in opposition online.
Thank you. Seeing no one, we will close the public hearing for application A2127. Next, we have application A-21-28. Is there someone here that would like to speak on this application? Thank you. We have the applicants Kent and Farron Brown. The owner is June Siemens. The present zoning is AR, agricultural residential. The proposed variance is from the required 25% maximum impervious surface coverage to legalize the existing impervious surface coverage on the property. Present use is residential. Proposed is the same. It's in the 5th Levy Court District for Mr. Sweeney, located on the north side of Fence Post Lane, southeast of Turkey Point Road, north of Iola. Here you will see that the lot size is 21,780 square feet. The existing impervious coverage is 8,850 square feet, totaling 40.6% impervious coverage. And again, the permitted impervious is 5,445 square feet, being 25%. You will see the front of the home with some of the asphalt driveway. Looking down the road, a fence post, and the other side. Here you will see the driveway with all of the asphalt, the home, and the garage. The backyard towards the patio. This is behind the detached garage. The aerial, this is not a current aerial, so it does not show all of the existing improvements. And the farther out. Ma'am, if you would like to come forward and state your name and address and allow our attorney to swear you in.
My name is Farron Brown. It's at 647 Fence Post Lane, Viola, 19979.
Ms. Brown, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Absolutely do. Good evening, everyone. Okay, so this is not something I usually do, but I am actually super grateful for the opportunity and for my kids to be here as well. As you know, we're seeking a variance for our impervious surface overage.
Excuse me, can you just pull the mic a little closer? You have such a
Sure.
soft voice.
Gotcha. Do you need me to start over? Are we good? Okay. I was born and raised here in Kent County, and I must say apologetically that this is something I was oblivious to. Growing up in construction, I have a passion for architecture and design, and I seek to make improvements that bring value to homes and communities that surround them, and planning this driveway was no different. Even before we made the decision, we took every step to prepare, and we made every precaution to accommodate our neighbor's property line worries, whose property sits back off the road, and the only property line that we share is part of her driveway. For visual, you can refer to the documents we submitted. Here in that document, you will see that the driveway easement separates 4 homes before it actually gets to her residence. In the preparation stage, I called permitting office multiple times regarding the process of our plan. On one occasion, we asked how close to the property line we could install our asphalt, and this was in an effort to make a clear line between the properties, again, based on our neighbors' fears of the crossing the property lines. And I was told that we could pour up to the line. Again, I called to make the reason we made the additional 3-foot strip of grass along the property line into asphalt was to clear boundary lines with our neighbor. On another occasion, I called to confirm that no permit was needed, especially considering the extra areas that we were pouring. I was told not from Kent County, but I needed to contact DelDOT. So that's what I did, and again, I was given the go-ahead. I was asked and once this all kind of shook out, I was asked if I knew who I talked to, and unfortunately, with the clear answers I was getting from everyone, it seemed unnecessary, but lesson learned. I was asked if I already said that part. In all the council and even the well-respected contractor, no one mentioned anything referring to the potential of an impervious overage. So ultimately, we just didn't know. However, when we were made aware, we quickly took accountability of the overage and made every attempt to make it right for our neighbors and the environment. I'm going to ask my husband to kind of come up next and just address the efforts that we took post finding out about our overage. Any questions
Okay,
for me?
so first, we're going to ask you questions,
Okay.
and because we do one at a time.
Great.
But he certainly will be welcome. And that's the end of your testimony okay. So does anybody have questions for this witness?
I have a couple. How close, do you know how close the asphalt that you put down is to your property line?
It is about 3 inches. They just gave us a little extra, but when I called it, it was like you can take it to the line.
Okay, and do you know approximately the distance between your driveway and the neighbor's driveway to the right?
Oh, it's about 9 feet. You can see it on the picture. It definitely, there's some pictures of that.
Okay. So we do have a letter of complaint that was registered. And in the letter, it states that you intend to apply for a home-based contractor establishment. Is that an intention?
No, that is incorrect.
That's incorrect, okay. I didn't see it listed anywhere in your remarks.
Right.
And the fact that without this variance, if you were to apply for that contractor establishment, without this, you wouldn't be able to. But you say that's incorrect.
I'm sorry, can you ask that again?
It's incorrect that
Yeah.
you're not going to
Absolutely, yep. We were asked about that, and ultimately, we knew it was it's like twofold variance we would have to apply for, and this is the only thing that we decided to.
Yeah. The area behind your garage, was all that asphalt put down at one time?
So
Like the
what
driveway and along the driveway and then behind?
So originally, when we moved there, and I think that you can kind of tell from this old picture here, that it was gravel. It was just a stone driveway. And then we put a pole barn, and then there was some concrete around the pole barn, and then the back section where there is a shed in this old picture was just mud and muck from the pole barn being constructed. And then 2020 didn't allow us to get everything done as quickly as we would have.
So is the pole barn still there?
Oh yeah.
So the asphalt is between the pole barn and your new garage you built?
Say that again. Yeah, can you, if you refer to the picture, I can totally. Yeah, so that's a pole barn. We made it look very aesthetically, so it almost looks like it's connected, but it's definitely the pole barn 2-car.
Okay. So the area behind the pole barn is all asphalt to the back of your property line?
Well, there's about 6 or 8 feet, I think. Maybe not quite that much, but we have large trees that we've grown all back in the back, and it goes before that. It ends before that.
Okay.
Yeah, you see the tree line? Mm-hmm. So.
Okay, thank you.
Anybody else? So essentially, you're here to legalize what has been done.
Exactly.
From an impervious soil standpoint, because as you testified, the testimony is, when you made the calls, there was no permit necessary for the blacktop, which would be so. So, so in each area, the driveway, what I'm just going to call the basketball court.
Yeah, okay.
You have 3 feet with the driveway, when you have how many feet between the end of the macadam and the trees, roughly? I don't need an exact.
16 feet, maybe? From the end of the pole barn, is that what you mean, to the tree?
No, from the, I see shadow in the trees. So obviously the macadam ends, then the trees are there. How much of that is soil between the two? The macadam doesn't go right up to the trees,
I'm
right?
not sure that I know what the word macadam, and like what
Blacktop.
Oh, okay.
I'm sorry.
Okay, so you're asking how much Blacktop is,
How much dirt is, I'm going to say dirt, grass, ground, soil between the end of that blacktop and the end of your property?
okay, so that's what I'm assuming is between 3 and 6 feet. That would be
Okay.
because those trees are ours.
Okay.
And they're huge. They're 20 foot and
Okay.
large.
Okay. And so when it rains, when we've had some relatively torrential downpours just even recently, does any water sit on your property?
Absolutely not. So I actually took some pictures after a downpour and I had them put them in our packet. And do you guys have those? There they are.
Yeah,
Yep.
we do.
And you can see that our driveway, and I know that another gentleman mentioned it earlier, how he's worked for an asphalt company, and we literally watched the water drain into the asphalt. And I mean, I don't know if it's new or what, but it's different to me. So we have that. We have zero runoff and zero pooling. The one area on the picture that I actually added was an area where there's some water in our backyard, and that has nothing to do with anything other than an old pool that we're still trying to get the sand and soil fixed from something that used to be there, which it was in an old picture.
Have you considered, as a potential way of resolving this, where that water is standing where your old pool was? It's obviously not being used for anything else, in making some kind of a rain garden to collect. The reason you don't have any, it's probably graded very well, and you are getting runoff because whatever water lands on your blacktop is not going right through it. It's going off. It might not be puddling and pooling, but it's going off. But quite often we have people come in with the same situation, and within their yard they'll create an area that is called a rain garden or whatever you want, where water collects and then naturally seeps in. You put certain shrubs, certain bushes in there that help absorb the water. That may be something that you might want to consider, because it may be asked later on.
So we actually reached, and my husband will touch on this, we actually talked to Kent Conservation and had him offer some suggestions, and we even brought those suggestions to mind to him, and he told us that he said they're always good, but he did not see a use for it at this particular property. Now, for where that pool is, we just got the grading newly completed, and we're bringing in some nicer fill dirt just to and kind of turned it over a couple times. It's actually a lot better. Where you see the pooling in the backyard right now is also because of the runoff from the shop. We have a downspout, and we have
Rain barrels.
Thank you. We have rain barrels. We have one on the other side that we use, and we have discussed putting one there because we just can't, unless we figure out a way to redrain or redirect that drain. It's going to be an issue from that's this metal roof causing a lot of water to run off.
Okay. Anybody else?
Is this fence that's in the photo of the blacktop, is that part of your property? Or okay, the fence post?
Yeah.
Okay.
I'm sorry, was there a question, or are you just trying to figure out like property lines?
I was just trying to figure out the property lines.
Okay, tell me which fence you're actually referring to then, the black one or? No, our neighbor actually just installed that.
I had a question for staff. How many feet do they have to be off the property line for a fence? Is it 5?
The fence can go right to the property line.
Thank you.
Anybody else? Thank you.
Is there anyone else that would like to speak in favor of this application? Please state your name and address and allow our attorney to swear you in.
Kent Brown, 647 Fence Post Lane, Viola, Delaware.
Mr. Brown, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Absolutely. So Farron did a good job. I don't feel like I have much to say now. As Farron mentioned, we did everything that we knew to do prior to installing the asphalt, and we were completely unaware of a code. So our bad on that. Lesson learned. I don't want to repeat what she's already said. I just want to touch on a couple of the response to staff recommendation report. Maybe we can kind of discuss those, go through those one by one. The nature of the zone where the property lies. We obviously met all criteria with the obvious exception to the impervious surface allowance, which we were not aware of. The character and use of the immediate vicinity, we have 2 teenagers and a 9-year-old. So the recreation area in the back was kind of in the midst of COVID. Kids are at home, and we wanted to create an extra area for them to be able to play. So that's the reason for the extra in the back there. So the removal of restriction to affect the neighboring properties. Once we received the official violation, we met with all the surrounding property owners and made time to answer their questions. We presented a statement in favor of the variance to give them an alternative option to public testimony in favor of the application. The most common response we received when talking to the neighbors was, "What's the problem? Everything looks great. You guys have done a good job cleaning up your property." We also reached out to Kent Conservation, which Farron mentioned. Spoke with Jared Atkins, and he had no objection, which you guys should have the letter of no objection in your packet. Is that correct?
Yes.
Okay. So I'd also like to point out that, just as you guys talked about, there's no standing water on the grass strip between our property and the neighboring driveway. We took pictures after a heavy rain just to prove that. We spent $12,000 to install the asphalt, so at this point, it would be a substantial loss to reverse that or to hire someone to remove a portion of it to meet the impervious code. So with that, we seek variance.
Okay, any other questions or?
Sure. Can you give me the approximate size of the asphalt behind your garage to the back of your property?
30 by 40.
And I'm going to just ask again, if it was presented that in order to approve this variance, that it'd be requested that you put on your property, and you have looks like an ideal spot for it, an area that would be designated as a rain garden or an area that would collect runoff from that 30 by 40 area. Would you be willing to look into that?
Absolutely. Yeah, I spoke with Jared about that when I was on the phone with him, Mr. Atkins, and he commented that would help offset some of the impervious. So absolutely.
Yeah, thank you.
Mm-hmm.
Anybody else? I think we're done. Thank you.
Thank you.
Is there anyone else that would like to speak in favor of this application? If you are on the phone, please press *3 to raise your hand.
No one online at this time.
Thank you. Is there anyone that would like to speak in opposition of this application? Please come forward and state your name and address and allow our attorney to swear you in.
My name is Antonia Shin. I live at 659 Fence Post Lane, Viola, 19979.
Ms. Shin, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes. I have copies of what I'm about to present for the court. So My property at 659 is an equine property. It's approximately 6 acres. And I'm here to express my concerns with this extensive impervious variance approval requested by 647 Fence Post Lane, which borders my property for a distance of approximately 180 feet. In addition to the more normal Fence Post Lane runoff, I'm aware of 5 properties in the vicinity which pump water from their properties into a drainage ditch which runs along the lane, and finally into a drainage ditch which runs on the south side of my property. I believe I've listed these properties that actually pump into the ditch along the street. I've also witnessed the fields of 2 additional properties which retain large amounts of water. Although I've never seen them try to pump it, eventually it drains into this ditch alongside the road as well. And that water eventually ends up in the ditch that runs alongside my property. All of this water and that of the adjoining farm fields overflow the ditch on my property and prevents my horse pastures from draining, and at times overflows into these pastures. I have 2 elderly horses, disabled, and bought this property hoping to use the grass in my fields to feed them. In past years, I have paid to overseed and fertilize, all for naught. Because of the extensive flooding, which at times can be 50% of the grazing area, the seed was destroyed and left behind grasses not palatable to the horses. While some grazing areas still exist, I am forced to buy 50 to 60 bales of hay annually at an average cost of $8 to $10 each. I keep my pastures free of manure and cut. However, there is standing water at all times in pastures and most times in the ditch, which leads to an increased mosquito population, and as I stated, an increased cost to feed my animals. I have been in contact with Mr. Biggs at DENREC Drainage Program since October 31st of 2018, when he took my formal complaint. At that time, he stated he had over 200 complaints in Kent County and was short-staffed. There is a pipe in the back which leads to a lake and may be the issue. He wasn't sure when he would be able to check on it due to the backlog, but even if it was determined to be the issue, it would take 12 months to resolve. He said a neighbor across Fence Post had also filed a complaint. I spoke to Mike today, and they are still 5 to 6 years backlogged. He has not had a chance to look to see if the pipe leading to the lake is an issue. Currently, DelDoc is replacing metal pipes running under roads and replacing them with concrete. Fence Post is currently marked for such replacement, which will increase the water flow into the ditch that adjoins my property. Lastly, where is the water runoff due to the increase in impervious surface from 647 Fence Post going to go? I am concerned with the additional water drainage onto the 15 feet of my property, which Ms. Brown had said is actually less than 15 feet. I didn't measure it, but there's a garage, there's a lean-to, there's a slate patio and blacktop that have all been installed between 2020 and 2021. There was a big muddy area behind their garage and along my property in which they paved over, but the entire driveway is graded to drain onto my property. I've included a photo. This muddy area was created when they put the garage and lean-to in. Paving this area doesn't mean the runoff no longer exists. They also state the use of a water barrel, which does not provide a permanent solution. What if the property is rented or sold? Who will maintain the water barrel? And where is the barrel located? It's not affixed to the downspout, which drains directly onto my property. I've enclosed a photo. And it appears I, too, will be forced to pump water into the ditch along the road and further stress my pastures. As the blacktop was installed directly on the property line in May 2021 to accommodate many personal and commercial vehicles. They have an RV, 2 full-size pickups, a full-size SUV, a regular-size SUV, 2 open trailers, 1 closed trailer, 2 ride-on mowers, a bobcat, a muscle car, an ATV, a golf cart, and a hunting shed. They're not all there at all times, but a lot of times several of those vehicles are there. Because of that, I installed a fence on June 21st of 2021. There's also photos of that. There is nothing to prevent the water from running off onto my property from the newly installed pervious surfaces, which are graded towards my property, nor the downspout on the side of the garage, of which I've included a photo. The water runoff has already impacted the fence, which was installed 24 days ago. I've included photos. And it is only a matter of time the runoff will impact my driveway, which lies below and 15 feet, what I thought was 15 feet, from these additional impervious surfaces. I seal coated my driveway in October 2020, and I'm wondering if that was also for naught. It's for these reasons I respectfully request the board not to approve the requested variance. Thank you.
Thank you. Does anybody have any questions?
One question. As previously stated by the owner, they didn't notice after they took photographs after a heavy rainfall, I guess fairly recently. The ground out where you all are and in parts of Kent County and all over change from seasonally. This time of year, you might get a 2 or 3 inch rain and the water be absorbed fairly quickly. Whereas in April, May, when the water tables obviously are higher, the water doesn't drain as well. So I don't know, you haven't had a chance since this was just installed to see what might happen in February, March, or April.
But that area does, even before they put the driveway in, that area does actually contain a lot of water or retain a lot of water.
Okay, thank you.
So my question is, you've lived there longer than they have, and prior to them putting all the different asphalt areas in so far, were you having drainage problems? Were you having minor ones that are now exacerbated to be really bad? Can you explain the difference between then and now?
So it's hard to say because it's just been put in, and the ground is pretty dry right now, drier than it has been. I mean, last year was a very wet year, and my fields were extremely wet last year, where this year, I do still have standing water, but not to the extent that I had last year. Now, this area that we're talking about, this grassy area, it does retain water because it's lower than their property and where they put their driveway, so everything did and does drain into that area. However, some of it was absorbed because it was a pervious surface. Now that it's not, everything's draining there. And you'll see from the photos of the damage it's already done to my fence that I just put in 24 days ago. My driveway's only, a few feet from that, and I don't know what the impact's going to be to that, or if I'm going to have to eventually, like I said, pump water out of that area into the street runoff as well.
Okay. Anybody else?
I have a question. So you believe the water that is on your grass is solely from the asphalt to the left of the grass? Like their asphalt, not your asphalt? Or am I not understanding?
I've never had any problem with any pooling on my driveway that, I don't know how long it's been there. Like I said, I just seal coated it in October.
How long have you had the driveway?
I don't know how long the driveway's been there. I've owned the property since 2016.
Okay, thank you.
Yeah.
Yeah, can you pull up an aerial, please? Thank you. So there is a residence behind the property we are talking about that separates your property, correct?
Mm-hmm.
So you were talking about a drain pipe. Where's that located at? That's affecting your horse pastures.
The drain pipe runs, so we're looking at the photo, if you see the tree line, looks like it's 2 properties over. There's a drain pipe, yes, that's it. There's a drain pipe on the road, which is currently being replaced by Del Doc. And that is a drainage ditch that runs all the way back to the tree line that intersects that. And there's another drainage there, and then that drainage goes all the way back to that next big clump of trees there. There's more water that comes in from that big tree area to the far right as well. And I believe that's where the trailer park is.
Is that considered a tax ditch or just a?
No, it's not a tax ditch.
Okay, anybody else?
If they completed all the stuff for the, like you say, if it's not hooked up to the rain barrel and places for that water to run, would you be happy with that?
So my concern goes beyond, yes, as long as it's not used for other purposes, okay? But the way that the property is set up and the building and the number of vehicles, which I've included, the number of vehicles, and I listed the number of vehicles that are on the property. I'm just concerned with it not being used for a residential purpose.
I have another question. You mentioned that this isn't a tax ditch, but you
Right.
reached out to Denrec.
Yes,
So who did they tell you owns that ditch if they don't take care of it?
I own half of it, and the adjoining farm field owns the other half.
And so what, do you maintain the ditch?
Yes.
Yeah, and so you have it whatever it is they do, mow them?
Right, we clean it out
occasionally.
periodically, but that stuff grows really fast.
Sure.
And most of the time, like I said, it's flooded and muddy, and, it's hard to get in there, but we do clean it out, yeah. And so do the neighbors that along the roadside there that also, their property also.
How often would you say you clean that ditch out?
Well, we haven't done it yet this year, but we did it last year, yeah.
So, and it's just kind of a shared responsibility that you both property owners agreed to, or is it written in your
No,
deed?
we're the only ones that clean it. I mean, the neighbors that are along the street, Fence Post Lane, they clean it, their portion of it. Then there's another house behind them. I don't think they clean it, and then we clean our section.
Okay. All right, anybody else? Thank you.
Okay, thank you.
Is there anyone else that would like to speak in opposition of this application?
So caller user number 3, you can I'll give your name and address and be sworn in at this time.
Yes, hi, my name is Max Simpson.
Sir.
I live at 659 Fence Post Lane in Viola. I am Tony's husband. You're pointing somewhere.
Caller online, we have someone in the room. Can you let the caller in the room proceed, and then we will come back to you for your comments.
Oh, you want me to proceed? Okay.
Sir,
Yes.
over here. Do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And if you would, could you repeat, because I don't think we heard it, your address?
My name is Max Simpson. My address is 659 Fence Post Lane, Viola 19979.
And he also mentioned that he was Mrs. Tony Shin's husband. Drew? Right, okay.
Okay, I'd like to take my allotted time here, my 5-minute window, to present my objections to the proposed variance to increase, I call it the impervious surface area, at 647 Fence Post Lane.
Did you swear
Tony's
him in? I'm sorry.
I did, yes.
Okay, thank you.
What? Tony's property is adjacent to 647 Lane. We've already established that, and I believe it will be negatively impacted over the long term if the variance is granted. The impact will be financial as well as quality of life related. We moved to this property a little over 5 years ago, viewing many other properties in Delaware, Maryland, and Pennsylvania. We were seeking a small horse farm where Tony could tend to her 2 horses, plant a garden, and in general enjoy her retirement. One of the factors we considered was the character of the neighborhood we were moving into. We looked at another property in Delaware that was almost perfect. The amount of acreage was almost double, and the house was larger and more modern, and the cost was about the same as the house we bought at 659 Fence Post Lane. The downside was the adjacent property was a commercial establishment. We had no desire to look at excavation equipment while we were enjoying the sunset. We settled on 659 Fence Post Lane because it was an established neighborhood with zoning laws governing the properties. That gave us some assurance that the property would have the same character when we left as it did when we moved in 5 years ago. As you have shown on the properties there, the picture that you have up there now, if you look at the house in question, there is very little asphalt. We have a single line, single story ranch house there, creating very little problems with impervious areas. Just along there talking about, I want to get into the impervious areas now. In our area, Kent County allows a maximum of 25% ISA to total area for the residential land parcels such as the lot in question. Now, you did put up a sheet that shows the rough numbers. They are they're running at 40% right now, and it should be 25%. That is approximately 60% over what is a very reasonable number of 25%, which protects the area for all of us. I did some research on this. Studies have shown that there is a correlation between ISA and water quality, water quantity, and water temperature. In other words, when the ISA percent increases, the water quality decreases, erosion, flooding increases, and water temperature rises. There are many factors that go into what these levels are, and it's not that easy to predict or anything. But I didn't read anywhere where it said that if I increase my pervious area in a particular area, it makes the water better. Nobody said it made the water better. They always said there were issues with the water. And I just, if anybody's interested, go on Google and do, hit ISA and problem area. You'll see tons and tons of articles regarding this problem for everybody. Just in the area we're in, I just say that most of the houses in this area are straight line ranches. 3 bedrooms, a bath and a half, 2 baths, whatever, a combination living room, dining room. Some of them have a 1-car garage, a 2-car garage. Some of them have stone driveways. Some of them have paved driveways. But the point is, on the size of the property they're on, they could have maybe 3,000 square feet of impervious area. Now that's just to walk through the neighborhood, I have a lot of experience looking at houses. The point is, they're well below, in that whole area, they're well below the 25% level that is Kent County allocates to this type of property. And that's good for all of us. Now, let me talk about options just a little bit here. When does this stop? In this area that we're in, as I've said, most of the people are good citizens, very little impervious area. Suppose you grant this exception to somebody that says, well, I didn't know about it, so please excuse me, I'm sorry, I won't do it again. What happens with what you say, okay, that's fine. What about the guy next door? He says, well, gee, they're allowed to do it. They're at 40%. Why can't I be at 40%? Why can't we all be at 40%? Because it deteriorates the land values and the quality of life in that area. That's why we have the rules to begin with, and that's why the rules should be followed.
Excuse me, I'm just going to ask you, as you're moving, we're losing you, and we record this entire hearing. So if you just kind of turn the mic so it's closer to you.
Okay, that better?
Please, thank you.
I'm sorry. Okay, now, who gains from this? Only the requester of the variance gains. Nobody else's property in that area is going to gain any value. In fact, if this granting of these variances is to continue, the properties are no doubt going to lose in value. Everybody gets hurt except the ones that wanted the variance. And lastly, I mean, we've been here a long time. What do I recommend? I recommend that you exercise your due diligence, keep this property at the 25% that it's supposed to be at. Everybody else has lived there for years and can exist on the 25%. Let's keep it that way. It's best for all of us. That's all I have. Any questions?
Anybody have any questions? I think we're good, thank you.
So caller online, I apologize for the mix-up earlier. You can give your name and the address and be sworn in at this time.
Hi, yeah, my name is Keith Bosco. My address is 25 Governors Avenue, Greenwood, Delaware.
Sir, do you affirm the testimony you're giving in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, please continue.
Okay. I had raised my hand earlier when Farron was speaking, and I don't know if it was delayed in picking up online, but I wanted to, after I heard some of the other arguments, talk a little bit about some of the vehicles that were in. I can speak. I heard that it was mentioned that there's an RV on the property there. I just want to testify that RV is actually my RV. And some of the reason for some of the vehicles there was their oldest son had just graduated high school, had family come into town, wanted a place for them to stay. So we had parked the RV there just for some people to be able to sleep in it. And it's just still there. So I wanted to speak to that, and then also speak to the character of the property owners. I've known them for probably over 13 years now. And I mean, they maintain property. It's always, I've seen they used to live in Bridgeville. Their property was exceptional. Everywhere they go, they take very good care of their property. They're very diligent. I just wanted to speak to that because I heard that there were some recommendations about some things that they could do to kind of like, kind of make things right. And I just know that they'll do everything that they can to do that. They sound like they've already sought some counsel from a conservation society. So I just want to testify to that and their character and their commitment to taking care of the property.
Okay, does anybody have questions? Well, I have one, which is how long you indicate that the RV is still there, and I'm wondering how long it will be before it will come back to you.
Yeah, I just haven't made that's partly my fault. I've just kind of got so busy, I haven't made the arrangements yet. But I guess, that's something that we'll have to talk about.
Okay. Anybody else?
That's something that I just got to get,
Okay. Anybody else?
Okay.
Thank you.
Is there anyone else that would like to speak on behalf of this application? State your name and address for the record.
Okay, just a point of order. We had, we heard some support there for the applicant, and I think that was during the phase of the hearing where we're hearing from opposition. I presume we're going to hear more opposition at this point. Is that right?
Yes, actually, we're still in opposition. The caller explained that we didn't notice his hand up, and which our system occasionally, I think, something like that happened. So yes, we are in the opposition phase here.
Good evening, Madam Chair and members of the board and staff. For the record, my name is John Pardee. I'm an attorney with the law firm Baird Mandalis Brockstedt here in Dover, and I represent Tony Shin, who you heard from earlier tonight. I'm handing out updated copies of the letter that I submitted earlier. Thank you very much. With some additional exhibits. And I don't intend to read the letter to you. You can read it at your leisure. But I did want to hit a couple highlights real quick, and I promise I'll be quick. First of all, if it's true that this application is not a precursor to an application for a home-based contractor application, then I apologize. That is information that I gleaned from a conversation I had with Sarah Kiefer last week, and it was my impression that that was the intent, and maybe that's not the intent. Maybe it never was, maybe it was, but it's not now. So in any event, you heard the applicant say that's not their intent, and we hope that they stick to that. The key thing here really is that the hardship that they're facing is, even by their own admission, one of their own making. It's self-imposed, and therefore it cannot be exceptional. And the staff report, I think, does a good job of explaining that. Your counsel has outlined the legal test 100% correctly. And the key points here are that this is not minimal. That's one part of the test. It has to be a minimal dimensional change. And the evidence is that it exceeds the 25% by a factor of more than 60%. It's not a couple of feet. You had an application earlier tonight where the gentleman was looking for, I think, 2.9 feet of road frontage. He was short. That's not this case. This case is a 60% exceedance above the limit. So it's not minimal. Additionally, this set of facts fails the other important element of the test, which is the balancing of harm that you have to weigh. And I think a fair characterization of the evidence is that there's already a bad drainage problem in this area. And as the staff report, I think, does a good job of pointing out, this can only make it worse. Now, you don't have the benefit of a full year of seasons to see it, but it should be obvious that if you exceed the impervious surface coverage limit on a lot by 60%, the drainage coming off that lot has to be more than it was before. It can't possibly be less. And as you heard earlier, where does that go? It goes on the other properties. A lot of the grading is towards Ms. Shin's property. So when you're balancing the relative harms, you've got on their side, whoops, we made a mistake, an honest mistake, I give them credit for that, but it's a mistake. And so the hardship is a self-imposed one. It cannot be exceptional as a matter of law. And so they would have to fix that mistake. They would have to remove some of the blacktop. And I understand that that is some expense, but unfortunately, they made a mistake, and that's not my client's fault. But the harm to other property owners, even if you have a bunch of neighbors saying they have no problem with it, you've got the immediate neighbor, immediately adjacent. Ms. Shin's driveway runs immediately parallel to this property. And she's testified very clearly how this impacts her. If you look at the photographs in Exhibit C to my letter, they show close-ups of the fence posts along the common property line, which has only been there for, I think, 24 days, Ms. Shin said, and it's already eroding away from water. So you've got evidence of the harm to Ms. Shin's property, and that harm clearly outweighs any harm to the applicants if this is denied. Couple other points. Look, the applicants, I take the facts as they've been delivered. They seem to be very good people. They have cleaned up their property. It does look very sharp, and they do a nice job. I mean, it's attractive, but it's also covering 40% of their property is a parking lot, okay? And it doesn't matter how many of your neighbors say, I don't have a problem with it. If one neighbor immediately adjacent is suffering damage as a result, that flunks the test. And that's the problem. So even though they're good people and most of the people in the neighborhood don't object or don't have a real problem with it, that's not the legal test. I would also point out that although Jared Atkins, as I understand it, wrote a letter of no objection, I think it's important to understand that there's been no study or test or investigation. Jared Atkins hasn't been out there. There's no evidence that anybody has really studied where this water is going and how bad the problem is. So I would respectfully submit, as much as I respect Jared Atkins, he hasn't really had a chance to look at the nature of the problem. So I wouldn't put too much weight on the fact that he wrote a letter saying I don't have an objection. There's been no study to show that KCD has evaluated the nature of the problem. So you've got the evidence before you is a self-imposed hardship, which doesn't count under the test. And you've got harm to a neighboring property owner. And then, so that's the second part of the test. And the first part of the test, it's not minimal. It's not minimal. So with all due respect, as good as the people might be, this application simply cannot possibly satisfy the quick check test. I thank you for your time, and I'm happy to answer any questions.
Does anybody have any questions of Mr. Bartier?
Thank you very much.
Good. Thank you.
Thank you.
Thank you. Is there anyone else in opposition of this application? Seeing no one, the public hearing for application A2128 is now closed.
Okay, so I have had some requests for a break, and so we will reconvene at 8:43.
Yes, ma'am.
far as doing the,
Yeah, when they make their decisions, so
Okay.
you're still here, so we'll do FAV and then.
All right.
So
Yeah,
everyone
great.
else seems to have left.
I
unless they
just
come back.
thought I had to answer a couple phone calls and messages.
Yeah. We got a lot of business, right? You know, next month's gonna be 2 variances, but it gets busy in the spring.
Yeah.
Get a lot of people doing stuff and needing variances, so. Yeah, they talked to you, about what we met. I know they, I guess Jason told me they're gonna have to.
Yeah, I saw you sent an email, and I
Temple Carter, report to your seat.
Okay, so, oh, we're missing one person. Our tech guy.
He went to go see if he could get the heat turned up.
Okay, so we're good. The only thing is, because we've had the hearing, so anybody who's listening will be listening. Okay, good enough. All right, so. Okay, so we're all back, and just to be sure, will you call the roll?
Yes, Miss Hudson.
Here.
Mr. Saunders.
Here.
Mr. Jenkins. Mr. Cusick.
Here.
Mr. Crossan.
Here.
Mr. Carter.
Here.
And Mrs. Denny.
Here.
So we have 5 present, 1 probably back, and 1 absent. I have 6 present. Well, yeah, okay.
So we're all here and ready. So at this point, we're calling the business meeting to order. And when we get to the cases, we will hear them in the order of the people, the order they were, the people who remain, and save all the others for after the people who remained know what their decision is. So at this point, first order of business is the minutes from the June meeting, which was June 17th. So I need a motion and a
I'll
second.
make a motion, we accept the minutes of the June 17th meeting as presented.
Crossan, second.
We have a motion. When you're ready, just call the roll. Oh, wait a minute. All in favor, aye. All in favor, say aye. Sorry.
Aye.
Aye.
I am going to just not vote because I wasn't here.
Saunders.
Okay.
Here.
So we have 4 ayes, 2 absent, and the motion passes. Okay. Just want to be sure number-wise. Okay. Notice of decisions.
I make a motion, Eric Crossan, I make a motion to approve the decisions for the June 17th, 2021 meeting, which included A, 2117, A, 2118, A, 2119, A, 2120, A, 2121, and I believe an old business, A, 2023.
Temple Carter, second.
We have a motion, a second. All in favor, aye.
Aye.
Aye. Any absent?
Absent.
Absent.
Okay, so same order. We had 2 abstaining, 4 voting, and so they are hereby approved. No old business. And here we are on it, new business, and again, we'll just start with who's in the order they were heard, but who's left behind.
Okay, the first one, as I see Mr. Johnson still back there, so we have A21-22, Jackie M. Johnson Jr., and this was for the impervious surface variance.
Okay, so I'm trying to find his. And mine are so out of order at this point. Hold on 1 second. So in the meantime, gentlemen, and lady, do we have any thoughts or feelings or for discussion or a motion? Okay.
I'll make a motion to
approved to legalize the existing 44.2% impervious surface, but deny the additional 2.4% increase to 46.6%, as there's no, per the testimony, I didn't see any hardship there. He didn't have any, didn't seem like he had any financial involvement at this point for the project.
Cross, and I'll second that motion.
Okay, so we have a motion and a second, and my understanding is that the motion is to approve what is currently there and to not allow the extra the extra add-on, just for clarification. So when you're, I'm sorry.
May I ask a question?
Sure.
Of staff. Is that part of the application to legalize what's already there, or is it just an application to increase the impervious soil, or, yeah, impervious surface from what it currently is to something else?
There was no formal request to actually legalize what was there. The request was to get a lean-to, which would require additional impervious surface compared to what's there now.
Right, so if the application is to add to the impervious soil, and were that to be denied, would there be an enforcement action that would ensue, or would the property remain in a non-compliant state, presumably? I mean, does the county take any affirmative action if the application is denied regarding the remaining violation?
Now that the county is aware of the exceedance,
okay.
Yes, I think it would be safe at the very least to legalize what is there by motion.
So the property now at 44.2%, I mean, if he wants to eliminate some driveway, and he could build the lean-to at that point.
That's correct. If you would legalize that number and he were to remove, I think, 288 square feet somewhere else of driveway and then replace it with the lean-to, he could still meet that variance that you would grant and still be in compliance with the variance.
So my question, Mr. Townsend, as you bring that up, is that the application that was filed to build a lean-to. They did not ask to legalize the existing. Is that so?
That's correct, Ms.
So
Tenney.
we didn't advertise that.
Mm-hmm.
I mean, we didn't have an application, and nor when these were posted in the paper did it say to legalize. And so that I'm asking for legal advice.
Well, that's exactly my question. If the application is just to add to the impervious surface, then I think that's the application that we're to act on, whether it's to approve the increase or to deny the variance and not approve the increase.
I believe there have been instances in the past where maybe the board has, I don't know if anyone has recollection, where we have, even if not granted additional whatever, they would at least legalize what's there.
I do remember some many years ago where we had one, and it was a similar question, because we were going to deny this addition, and it was more significant than this. Mm-hmm. It was like a whole garage or something, and the council at that time pretty much indicated that it's almost like you was understood. If you're saying that you're going to deny this, then whatever was printed in the paper and printed that says this is what it is, and essentially it could be assumed legally at some point that you approved what was already broken, but we didn't have to use the words to fix it, if that makes sense. But
Mr. Townsend, is there another tack on this? So if the applicant's asking for 46.6, could they give them a modified variance of 44.2?
So that's exactly what I was going to suggest, is that if that is consistent with what the maker of the motion and the seconder had in mind, that it could be interpreted instead as a modified approval, that may be justifiable.
Yeah, that makes sense.
So then they wouldn't get the addition, but then somebody won't come back and say, you're not legal now. Okay. Okay, so, good, thank you.
Is that perhaps a motion you would want to rephrase?
Sure thing. I'll make a motion for a modified, shoot, I don't even have the right application up. Modified approval for the site that is currently at 44.2% impervious surface, remain at that.
And then do we then deny the increase of the 2.4, or you just say?
I think the motion is to grant a modified approval of up to 44.2% impervious surface. Is that right?
Yeah.
Okay.
Crossan, I'll second that new modified motion.
Okay, so we have a motion and a second, and when you're ready, call the roll.
Thank you. Ms. Hudson?
For A-21-22, I vote to approve the modified up to 44.2% based off staff recommendation and how the applicant was willing to work with the board. Thank you.
Mr. Saunders?
I vote on A-21-2 to a modified approval of the 44.2% based on staff recommendation.
So if I could interrupt, staff recommendation was denial. Okay, I just want to make sure everybody understands.
I thought they voted to approve up to 44.
Yeah, they do.
That's in the report?
Yeah.
Staff has reviewed the information presented by the applicant and recommends that the board strongly consider the testimony, and the staff recommends denial of the variance for additional impervious soil. However, staff recommends the board legalize the existing impervious surface on the properties. And then, of course, it says that these are based on it.
I apologize for interrupting.
Mr. Carter?
I'll vote yes on the motion based on the testimony tonight.
Mr. Carlson?
I vote yes for the modified 4.2 impervious surface based on the staff's recommendation, and also the fact that, just based on the staff's recommendation and the testimony given this evening.
Thank you. Mr. Cusick?
I vote yes for the modified approval, the application A-21-22 per my motion.
And Ms. Stenny?
I vote yes for the modified approval. I do agree with the comments the staff made in their report about the character of the property, of the area, and that increasing impervious surface by adding lean-to can affect the neighboring property. So I vote yes.
Okay, vote shows 6 yeas, 0 nays, and 1 absent for a modified approval.
Okay, having received unanimous votes, the modified approval carries, and so while they cannot add the lean-to, they have been approved for the 44.2 feet that is existing.
Okay, so the next application, I see the Hardesties are still here. So A21-26, the Hardesties.
Okay, Okay, any thoughts, comments, or a motion?
I'll make a motion to approve application A21-26. Per the testimony, the applicant is doing his due diligence to get to the necessary square footage with the existing dwelling by finishing off the garage and then also adding in the addition, the future addition in the next year or so. And also it's a very wooded lot, so I don't think it has any impact on the surrounding community, the neighboring properties. And also the hardship of the financial hardship that's there for that he already put down for the lumber and to be able to construct the building.
Second.
Okay, so we have a motion, and a second, and when you're ready, call the roll.
Thank you, Mr. Saunders.
I recommend on A-21-22, to approve it based upon the testimony, him doing his, as he said, the due diligence, making sure he's going to add on to that house to make it meet the requirements as well.
Okay, thank you. Mr. Carlson.
This is A21-26, correct?
Yes.
I will vote to approve A21-26. I still find it hard to believe that without a permit, they would have purchased the materials that they did, and they would have been allowed to do so by the builder. However, it looks like the hardship is there, and they are doing what they need to do to bring up the square footage to meet the required square footage. So in this case, I'll vote for approval.
Thank you, Ms. Hudson.
For A-21-26, I vote to approve based off testimony from the applicant. He was willing to work with the board, and we're really talking about 10 feet. Like Crossan said, it's really hard to believe the builder would not educate them on this, and he's willing to work and add on to his existing property. So I vote to approve.
Thank you, Mr. Carter.
On A21-26, I will vote in favor of the motion to approve this application based on the testimony tonight, with different timing. Had they built the addition first, they wouldn't need the variance, but.
Thank you, Mr. Cusick.
I vote yes per my motion.
Thank you, Ms. Stenny.
I'm going to vote yes. I do believe, and my vote is based on the fact that they do intend to make improvements to the house, and which will add on the appropriate amount of footage to legalize. It's just, this is kind of the bridge. And so, therefore, I'm voting yes.
Thank you. So for 821-26, we have 6 yeas, 0 nays, and 1 absent.
So, having received unanimous positive votes, application A 2126 is hereby approved.
Okay, the next property, I see Mr. Scott's still here. So 821-27, Wilker Ochoa, FAV Properties LLC.
I make a motion that we approve A-21-27 based off staff recommendation for the modified approval, which was the, do I need to say it or can, okay.
Second.
Is this the modified, is this the, for the modified, okay, for the 5-foot?
But there's a bunch of requests that need to go through.
You can choose to approve them or approve them all together or do them individually.
No, we'll do it all at one time.
So essentially, your motion, oh, go ahead, you have it?
I'll pass my motion across and he's set, ready to roll.
I'll do it. I'll make a modified approval for application A21-27 to allow the applicant to have a 5-foot front setback for parking from the front property line off Hatchery Road, a side parking setback of 0.4 feet on the northern adjacent non-residential property and 0 feet from the southern adjacent non-residential property, a 5-foot planted area for the off-street parking that butts a road right-of-way, and approval of the complete relief from the interior plan and area requirements for single row parking. And that modified approval is based on staff recommendation. Also the hardship that's required for the parking to fit within this site to have this business exceed.
Second.
So you have a motion and second when you're ready.
Okay, Ms. Hudson.
For A-21-27, I vote to approve the modified approval based off the staff recommendation. I do not see where anything would change the character or the nature of the property lines.
Thank you. Mr. Crossan.
I'll vote yes for the modify on A-21-27 for the modified approval based on the staff's recommendations, and that there are other properties adjacent that do not meet the front or side setbacks, and that without granting the staff's modified changes, the applicant would not be able to upgrade the site due to the existing codes and setbacks.
Thank you, Mr. Saunders.
Vote on A-21-27 to the modified approval based upon staff recommendations. Also, I believe it would be a hardship if they're unable to have any parking to do any business there.
Great, thank you. Mr. Carter.
I'll vote yes on A-21-27 based on the staff recommendation and testimony tonight.
Mr. Kusick.
I vote yes for my motion.
And Ms. Stenny.
I'm going to vote yes. And just be very careful here in not setting any precedent. But this particular area, this right along Hatchery Road, I think we all know is very, very unique and has its issues. And I just also want to mention that while we do have a letter from Mr. Hunter asking that we not approve this. His concerns were rectified by the changes that were made in the modification. So I'm going to say yes.
Okay, thank you. For application A21-27, we have 6 yeas, 0 nays, and 1 absent.
Okay, having received unanimous positive votes from those present, application A21-27 has been approved with a modified approval.
Okay, the next people that are still here are the Browns. So A21-28, Kenton Fair and Brown, owner June Seaman.
I'm going to make a motion to approve application A21-28. I think per the report that we received, the overwhelming support of the neighboring properties weighed heavily on my decision, as well as the due diligence that the applicant put forth in contacting KCD and the response that KCD gave back, as that will not affect the neighboring properties, the stormwater runoff, and then the financial hardship to uninstall the asphalt.
I second that.
So we have a motion, a second, when you're ready.
Thank you. Mr. Crossan.
I vote A2128 to deny the application based on the staff's recommendations, also based on the testimony from the adjacent property owners. I don't feel that although there were a number of other property owners that acted in support, the one that's most affected is the one that's right next to the property. The impervious surfaces in question were installed at a time of the year when the water tables are lower, and it hasn't been tested. Late winter, spring, when the runoff is could very possibly be a problem. It's already been noted that there's drainage problems in the area, and this was just an excessive amount of blacktop to put down, especially behind the garage, simply to allow for some sports, some basketball, go almost all the way to the back of the property. So I don't feel that it's fair in this case to the property owner that is in question to approve. So I disapprove, deny the.
Thank you, Mr. Crossan. Mr. Saunders.
Vote on A-21-24, 28, to approve. I believe that from the testimony that we had, they did all their due diligence. They're willing to fix all the other issues dealing with the water. And I believe, Kent County is underwater all the time anyway.
Great, thank you. Mr. Carter.
On A2128, I'm going to vote no on the motion based on the staff recommendation and testimony tonight.
Thank you. Ms. Hudson.
For A-21-28, I vote to approve. I believe the nature of the zone where the property line does not change, the character and the use of the immediate property does not change, and there is a financial hardship of $12,000 from the applicant to have to rip up the asphalt. They did their due diligence. They contacted the correct departments, and they were trying to make it work, and it was just an error, or something that slipped through the cracks. Thank you.
Thank you, Ms. Hudson. Mr. Cusick.
I vote yes per my motion.
And Ms. Denny.
I'm going to vote to deny because I think that this is just a huge amount of blacktop. It's like, and we had testimony this evening with photos about an increase in draining issues for an adjacent neighbor. And to me, it's like when you do something that has that type of effect on a neighboring property, I think that it's not acceptable. It appeared to me in the photographs that especially the ones where you see the vehicles parked, that essentially some of that, the width of that driveway is just there for the convenience of being able to park vehicles that should be not out all stacked up in the driveway, in my opinion. So therefore, I vote to deny.
Okay, thank you. For A2128, for a motion to approve the variance request, we have 3 yeas, 3 nays, and 1 absent.
So I need advice from council because we're at a tie.
So if you had a motion to deny and you were tied 3-3, then you would need to entertain another motion because you hadn't passed anything. The applicant has the burden of persuading the board or 4 members of the board to support their application. The motion was to approve, the motion failed, so in my view, no further action is necessary on the part of the board.
And so the motion is denied and the application fails.
That's right.
Okay. Okay, so based on the 3 motions to deny, the motion to deny passes. The motion to approve failed, and
consequently the application fails.
The application is denied.
Right.
Okay, moving on to the next ones. I don't believe anyone's left that hasn't already been addressed, so we'll start in order. A2123, Lisa Skew-Soloway.
I make a motion that we approve A-21-23 based off staff recommendation. She was here a year ago, just happened to forget about the expiration date of her variance. The nature of the zone does not change. The characteristic and the use of the property still doesn't change, so I vote to approve.
Crossan, second.
Okay, so we have a motion second. When you're ready.
Okay, thank you. Mr. Cusick.
I vote yes to approve application A21-23 per the staff recommendation. The minimal impact on the neighboring properties and the surrounding community, and then the hardship to not be able to construct the second floor to improve the home.
Thank you. Mr. Carter.
I'll vote yes to approve A2123 based on the staff recommendation and the fact that we approved this a year ago.
Thank you. Mr. Saunders.
I vote yes to approve A-21-23 based upon staff recommendations as well as previously approved.
Mr. Carlson.
I vote yes to approve A21-23 based on the fact that we had approved this before and it just expired. Nothing has changed since then. Would not affect any neighboring properties. No objections from any neighbors, and the staff recommends the same.
Ms. Hudson.
I vote yes based off my motion.
Thank you, Ms. Stenny.
I'm going to vote yes. As my colleague stated, we're simply proving something that has already been approved in the past, and if not, but for the timing and COVID, it sounds like it would have been done.
Thank you. On A21-23, we have 6 yeas, 0 nays, and 1 absent.
Having received unanimous votes, application A2123 is hereby approved.
The next application is A21-24, John Cox.
Crossan, I'll make a motion to approve A2124 from the 75-foot yard setback to front setback to 64 feet with an 11-foot difference. The property would still be within character of the vicinity. No neighbors would be affected, and several of the other structures in the area are closer than 75 feet as well. The change would not affect or block any views of traffic. Because of the shape of the property, there is an exceptional practical difficulty would be imposed due to the existing setbacks and prevent the owner from constructing a reasonable sized dwelling on the property.
Second.
So we have a motion and a second. When you're ready, call the roll.
Ms. Hudson.
For A-21-24, I vote to approve based off staff recommendation. The nature of the zone does not change, nor does the character of the use. And by removing the restriction, the applicant will be able to better the value of their current property.
Thank you, Mr. Saunders.
I vote A-21-24 to approve the 64 foot from the property line based upon staff recommendations. I don't feel that the removal of the restriction of the applicant's property would seriously affect any neighboring properties.
Thank you, Mr. Kusick.
I vote yes to approve application A21-24 per the staff recommendation. The existing home was 60.4 feet, and then the new home 64 feet, so it won't affect the community, the neighboring properties, also the uniqueness of the lot, the unbuildable, shallow, and long lot.
Thank you, Mr. Carter.
On A2124, I vote yes to approve based on the staff recommendation and the testimony tonight.
Thank you, Mr. Crossan.
I vote to approve A2124 based on my motion.
And Ms. Stenny.
I'm going to vote yes. I think this is a very unique piece of property, and I feel like it's not totally unbuildable, but it really, you cannot do much to improve this without this variance. So again, not trying to set any precedents here. It has to do with the configuration of this particular lot, and what already exists is we're not making it that much different. So therefore, yes.
Thank you. On application A21-24, we have 6 yeas, 0 nays, and 1 absent.
Having received unanimous positive votes, application A2124 is hereby approved.
And the last application for the evening is A21-25, Sean Bowman.
Crossan, I'll make a motion to approve A2125 based on the staff's recommendations in requiring from the required 200 feet frontage to 197.01 with a 2.99 foot difference. In granting the variance, it would not be noticeable or affect any neighboring properties. The adjacent property has only 175 foot frontage, and reducing the frontage by 2.99 feet would prevent the owner from not reducing or not allowing the variance would prevent the owner from having to survey an additional 2.99 feet of property from the adjacent parcel to meet the 200-foot requirement, or ask neighbors to adjust their lot lines, thus creating exceptional practical difficulty.
Second.
Motion a second. When you're ready, call the vote.
Thank you. Mr. Saunders?
I vote on A-21-25 to approve the zoning, to move it from 200 feet to 197.1 of road frontage. I don't believe that you'd be able to notice the difference by driving by it.
Thank you. Ms. Hudson?
For A-21-25, I vote to approve based off staff recommendation. The nature of the zone does not change. The character and the use of the immediate facility does not change. And I do believe that the 2.9 feet would not be noticeable.
Okay, thank you. Mr. Cusick?
I vote yes to approve application A-21-25 per staff recommendation and the minimal impact of the 3 feet, which will have no impact on the surrounding area, as well as the hardship to have the applicant relocate any lot lines to recreate that 3 feet.
Thank you. Mr. Carter?
On A-21-25, I vote yes to approve based on the staff recommendation and testimony tonight, and I don't think there'll be any change in the immediate area.
Mr. Crossan?
I vote yes to approve, what was it? A-21-25 based on my motion.
Thank you. And Ms. Stenny?
I'm going to vote yes. Based on the, the uniqueness of the situation, as well as the staff's response, they said that that it's unlikely, it's such small change that it's unlikely to even be noticeable. And again, I don't want to set a precedence here, but it's unique. So therefore, yes.
Okay, thank you, Ms. Stenny. On application A-21-25, we have 6 yeas and 0 nays with 1 member absent.
Having received unanimous positive votes, application A-21-25 is hereby approved. At this point, I'm looking for a motion to adjourn.
Make a motion, we adjourn.
You can talk to us after we adjourn, but you can't talk to us while we're still, okay, so 1 minute. Okay.
I make a motion to adjourn.
All in favor?
Aye.
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 Any nays? Hearing none, we're adjourned.
Thank you. Who was the second? I'm sorry, I didn't hear. There was a motion and a
Second, Crossan.
Thank you, Mr. Crossan.
Items from the floor are still part of the meeting, so I just didn't know when to bring that up.
It's okay. It's okay.
So ultimately, I am up here because there is no resolution for our situation. We have 3 nays, 3 yays, and 1 absent. So we're a little bit of a standstill. I did hear the attorney's, Mr. Townsend's comment on that, but I also know the nature of boards in a lot of ways that there's a little bit of a question in your decision on that. So I'd like just a little bit more information maybe on that, or at least come up with a modification. And I know we're all ready to go home, but I've got, we'll wait, one more comment. Another gentleman tonight was approved to keep his existing at 44%, and we're at 40. So I feel like we're apples to apples, but you chose his. But you looked at that, and it was only the land, but he didn't get the addition, the lean-to, but his property looked exactly like ours with the pavement and concrete situation at his house. I think you guys saw those pictures.
Number one, And I've been doing this for, I don't know, I feel like it's 20 years, something like that, but, thank you. So, but they're very different, and yet I do fully understand how you might be sitting there thinking, why him, why not us? Well, here's the biggest number, the number one why is you're causing drainage issue on a neighboring property.
Right, and again, I know that she brought pictures, and I know that I brought pictures, and you can see on the pictures that I did bring, her driveway was pooling. Her driveway has always pooled. And another thing that was mentioned was that we have actually owned this property for 16 years.